Again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Frankie Rose's Think Tank. Here's your host, Frankie Rose.
Hey guys, welcome to the Think Tank. So we are going to take a look at the jury instructions this morning for Franklin Tyrone Tucker in the Treehouse M case. So they were supposed to do this yesterday, but the prosecution was a little bit behind. So they bumped it to this morning. But I'm seeing that the courthouse is still running late. So with that said, hopefully they get this going soon. I've been looking for Adam Montgomery. I wanted to stream that to you guys today, but I'm not seeing anything yet. And if that doesn't pop up, I might do a little bit of Ethan Crumbley. His mother is on trial right now for some of the misdeeds that he did. If you remember, he was the guy that was the school SHOOTER. So yeah, we might take a look at that as well. Let me see here. Let's see what's up. So yeah, nothing as far as Adam Montgomery, unless I have my times wrong. And Jennifer Crumbley, Ethan's mother, that could be really interesting. So we will wait and see how this goes. So he is in the Treehouse trial. He is defending himself pro se, is what they call it. So it's going to be really, really interesting to see how this works out. Yeah, nothing on Adam Montgomery at this point. So he's Harmony's dad. So he unalived, allegedly, Harmony Montgomery, who was just the sweetest little 5-year-old ever. Okay, here. Why are they behind again? Ooh, not a good look. The judge was upset yesterday. He was very frustrated. They said they needed 15 minutes longer after the break. And then they said, well, another 10 minutes after the break. And they were going to they actually had a bailiff doing some stuff for them. The judge just kind of looked at them like, what? So I don't know if they got the best prosecution here either. So I just don't know how this is going to work out. It's interesting. As far as I'm concerned, yesterday we watched the Good Morning. Do you know what, Shauna? You're not the only one. You're not the only one. I'm noticing a lot of people are saying they're not getting their notifications. So, I mean, YouTube at its finest again. I'll make sure that what I'll do right now is I will put the stream out. We'll do it that way. They're still not in court, so we've got a little bit of time here. So it'll end up being jury instructions and then deliberations, and Lord only knows how long that's going to take. But we will be all over this. Okay, so I put it out there. I think what I'll do is I'll also put it in here. And here. And here. If I could, I wouldn't sleep. I'd just 24/7 be doing this for you guys. The sleep factor is getting in my way. Yeah, you know, there's so many weird things that is going on with them right now, friend. It'll show, I'll have a stream where we get, 20 people in visiting, and I'll look up and it'll show that nobody's watching. And then we'll end the stream and, I'm watching to see what's going on in the chat. And I'll end the stream up and go to look at my analytics, and it'll show that there was 1 view. And then 15 minutes later, 2 views. So lots of things are going on with them. I'm not really overly impressed. We work our butts off at this stuff, and it's almost like selective. I don't know what's going on with them. I really don't. Okay, let me get kind of comfy here if I can. Well, we're not missing anything because the court's behind again. We're 10 minutes behind. Okay, so I am still going to. I need to know. I thought for sure they were streaming Adam Montgomery. No go yet. But yeah, Jennifer Crumbly's all over the place. Just the most bizarre thing. I don't even know if I need to cover that like everybody's doing it. Could wake up to Tony's music. There we go, friends.
Okay.
Well, hello,
Yes,
Sam.
sir.
I am.
You go ahead and push play.
Every story, and you should never judge a person based on one version of the story. That no matter how thin you hold a piece of paper, there's 2 sides to the paper. So I'm going to tell you what I have so far on the side
I think you're right.
that is not in your favor, and then give you an opportunity to fill in the gaps, correct any misinformation you think we may have, and tell your side of the story.
What the hell?
Tonight, your first, last, and only chance to give us your side of the story, because beyond here, how you know how it works. Attorneys get involved, and then attorneys tell them you're not to talk, and that's why I'm trying to talk. So, let me get it straight. Well, because that's the thing, man, I ain't got on the high, that's why I'm here for tonight, and otherwise, it would have been like, man, if I thought I needed an attorney, I would have been like, look, I need a lawyer, you know what I mean? But I know I haven't done it.
I don't know what the heck here.
I'm gonna let you know a couple of things.
Most interesting.
Detective picture is absolutely accurate with the timestamp on the video.
Where are we watching this?
Walking on Second Street.
Is this somehow something to do with jury instructions?
At 8:15 p.m.
How bizarre, how bizarre.
Telling our dispatchers that a guy has been stabbed, he's dead, and he's laying face out in a pool of blood. So you have 4 minutes from where you're at to where this thing happens. Now, the really disconcerting part of all of this is at 8:19.
Wow.
4 minutes after we have a report of a man being killed.
If anybody sees anything about Adam Montgomery, can you let me know? Because I'm finding nothing. Yeah, I don't know. I agree. I'm a little confused why they're showing this, though. Is he wearing the same stuff as yesterday? His billionaire, yeah, that's who we're looking at, friend. Same stream. Are you talking about, unless I'm understanding wrong? Are you saying Adam Montgomery's on? Looking.
In the walk from Laurel Avenue on Second Street to where you live, we found in lot 72 a knife. Okay, on that knife is blood, and on the handle of that blood, latent DNA. That's going to the lab. Okay, and a little further up the road, in the back of the boat, parked alongside Second Street, is a mask.
Well, I'll just keep my eyes peeled.
Very weird, creepy, scary face on it, but it's also made out of foam, and on the front of the mask are 3 blood.
Someone's covering OJ. That's hilarious.
Electric band that goes around the back of the head, and a nice foam pad in the front.
Ah, okay, thank you.
Okay, now all that stuff's gonna go to the lab. Okay.
I had no idea why we're watching this.
Okay.
Because are they showing this to the jury? I can't see it.
We have wounds on our
He looks pissed again.
that are consistent with the knife that was found in lot 72. So what
We're trying to listen to the
know
video.
is
Thank you.
that this story and the details of the story
Oh, don't be sorry.
not stacking up in your favor. I'm just saying all that stuff.
Don't be sorry.
You're not gonna find anything there for him, with my, with anything mine on it. I mean, granted, if the mask came from the house.
Is it cold in the courtroom? Because it looks like maybe he's got a suit or something under that. Hi, Perry. We're supposed to be looking at closing arguments. Of course, Sam. We're trying to figure out, this is supposed to be closing arguments, so not quite sure why we're looking at this stuff.
I mean, the timestamp with the video, I mean, like I said, that one was coaching.
Okay. So I'm trying to understand the exact nature of your Rory tennis motion. Now, what is it that you're asking me to do?
I would ask this, Your Honor. I mean, because again, to be fair, and like I said, to make sure that the jury has the
Hey,
right
American.
information, I would either
Good
ask the
morning.
video be allowed to be back with the deliberations, or that Your Honor, instruct the jury.
Okay, so I don't see a problem, but we'll hear what the state's.
No, live in court. We're live in court.
No, it's Matt Bonnet's blood on the knife. They simply identified the evidence that they have. He deduced that it was Matt Bonnet's blood and told Paul Belmonte. This video is not evidence. We haven't contradicted anything in evidence. We made argument. So I would submit to the court, there's nothing here to rule on other than nothing, really.
Your Honor, if I might. No, they said this was their single most compelling piece of evidence, that there was no way I could have known.
Okay, but stop.
And
Stop
yes.
it. What, get to the point that somehow or other, they were misrepresenting the state of affairs because they knew that someone had told you that it was Matt Bonnet's blood and they intentionally misrepresented that? Is that what you're claiming?
Yes, I am saying that. Your
Well,
Honor.
that video doesn't establish that.
Your Honor, I definitely could infer from what she just told me that that was Matthew Bonnet's blood. If it's consistent with the knife wounds, if again, they have blood on the knife, then it only, it only stands to reason that it's Matthew Bonnet's blood. I mean, again, they're purporting that conversation to be something that is totally evident that I had to be there. And no, and they said there was no possible way for me to know. Well, yes, there is.
Okay, thank you. I'm denying the motion. I find that the information conveyed to the defendant during the Penny Phelps interview is not inconsistent with the state's argument. There was mention of blood found.
Yep.
It was never.
You're right.
In fact, I believe there was indication it was going to be sent
I
for
agree.
testing, but it was never told to you, oh, that's Matt Bonnet, that's Matt's blood. It was not. So anyway, Mr. Tucker, I've made my decision. I recollect that, can we, no, sir, I'm not going to argue any further. I've heard your motion. I've made my decision. I allowed you to, when the state objected during closings, you're right, they can't use something as a sword and a shield. That didn't come in because of the interview, the statement, because it's a prior consistent statement, basically, that's inadmissible. But when they objected and you started to talk about this particular interview, I overruled the objection and said that you could mention that you were at the station for a long period of time and questioned about the event. So I allowed you to make some explanation. I didn't allow you to go into what was said, but yes, sir, you have.
I'm not trying to argue.
Well, that's what you're doing. If you had a question about my ruling, that's fine, but.
I do.
Okay.
I'm not trying to argue.
Wilson, what's your question?
Your Honor, yes, I know that Your Honor overruled their objection.
Right.
You did establish that I could talk about being at the station. I could not talk about what the hearsay would have been if what I was told. And I really do think, Your Honor, I mean, it is very, very, misleading to the jury to allow them to go back there and deliberate on something that could cost me my life based on, information that, again, they're not being provided the entire amount of information concerning what the major part of their case is.
Okay, I understand your position.
Yes, he was.
The Ori Tennis motion for finding no violation, allowed the video to be played in the record, allowed the Ori Tennis motion, heard substantial argument, made a decision, provided rationale to support the decision. Understand you disagree with it. Understand you've preserved the issue should it become necessary, but in any event.
I'll go ahead and take the video off there.
Okay, I don't mind.
Wow. Don't argue so much, mister. Sit the frick down.
I saw Kerry in here. Did he want to come in here, or could we ask Deputy Rico's there? Because I saw Kerry and there was some question about the operation.
I think you're right.
I saw him come in here earlier. I assume he wanted to check something. It's unbelievable. The AC has to be malfunctioning. It's unbelievable. I don't know. I'll go check with court administration while Kerry's doing this. I'll be right back.
Here we go again. Yep, they sure do. He was trying to add a few things. Or delete a few things. I'm just tired of them now. Yep, not happy. I just get this guy out of my court. Your hair, if that's you in your picture, is freaking beautiful, friend. My word. Yeah. Yep, they get to miss all this hoopla. They see it after. You sure can. Good Lord. Martha. So we missed a few days of this. We got busy looking at the Michelle Troconis trial, and that's the Jennifer Dulos who went missing, and they found all of that substances, DNA, I guess, all over the garage. And now they've brought in like a lot of different evidence. No, I don't think he does. I was asking about you. If your hair's down to like your butt. I haven't seen anything yet.
I imagine we'll be around. Okay, do we have all the jurors present?
Your Honor, the only remaining, I guess, issue is the unbolded
Oh,
3.10. It's really up to the defendant and the court. I just did it.
well, it's fine. It's with me. We mentioned the.
No, as long as it's the same
Yeah,
document.
it's the same one here. Same
Is he on his phone?
Which number is it?
3.10.
Yes.
Yeah, your hair. I'm just looking at your picture there and seeing all that hair. It's like, oh my God, that's gorgeous. Fair enough. I couldn't watch that lawyer anymore, Saul. I had to get away from the Dulos case for a bit. That lawyer was making me want to throw my computer around the house.
Same package?
Yes, I'm thinking about covering that next.
I already got this one completely organized.
I wanted to do Harmony Montgomery's dad, Adam Montgomery, but I'm not seeing a link. So I might just jump straight over there. We'll see how it goes.
0.10.
And then we'll just watch for everybody get called back in when they get a verdict.
Okay, that is in lighter type, consistent with the type of the other instructions. So I'll substitute the one that's darker for the one that's lighter. It says the same thing. Thank you. Let's bring the jury.
He sounds irritated. Did there? I'll have to look into that. Yes, it could. Oh, I love it. Yeah. Crumbly.
Thank you. Please be seated, everyone.
Yeah.
Good morning. Good to see you all here again this morning, members of the jury.
I
So-
seen that.
Yesterday, you heard closing arguments.
I noticed that.
And I told you that in light of the hour and the like, that it seemed to me to make more sense to send you home for the evening, to take care of the business that we needed to take care of, and to have you come back this morning so you could receive jury instructions and have ample time for your deliberations. And so here we are to do that. So I'm going to now instruct you on the law applicable to the case. I'm going to use this packet of written instructions, basically verbatim. When you go back to deliberate, along with the evidence, you're going to have this packet of instructions, exactly what I'm using to instruct you. So you'll have both the verbal instructions and the written package. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Franklin Tyrone Tucker has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. Franklin Tyrone Tucker, the defendant in this case, has been accused of the crime of first-degree felony murder, robbery with a deadly weapon while masked, aggravated assault while masked, and battery while masked. If the defendant helped another person or persons attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, number one, the defendant intended the crime to occur, and number two, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For first-degree felony murder and second-degree murder, it is not necessary for the state to prove the defendant intended the death of Matthew Reed Bonnet. It is not necessary for a principal to know every detail of how a first-degree felony murder, second-degree murder, robbery, aggravated assault, or battery will be committed, as long as the principal intended the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur, and did some act or said something that was intended to help and did help the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur. To be found guilty of a first-degree felony murder, second-degree murder, robbery, aggravated assault, battery, as a principal, it is not necessary for the state to prove a defendant knew another participant of the first-degree felony murder, second-degree murder, robbery, aggravated assault, or battery while armed. Franklin Tyrone Tucker is accused of first-degree felony murder in count 1 of the indictment. First-degree murder includes the lesser crimes of second-degree murder, manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Matthew Reed Bonnet was killed by Franklin Tyrone Tucker, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree felony murder or second-degree murder, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful and under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and in misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Franklin Tyrone Tucker may be found guilty of first-degree felony murder or any lesser included crime. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Matthew Reed Bonnet is dead. Number two, while engaged in the commission of a robbery, Franklin Tyrone Tucker caused the death of Matthew Reed Bonnet. Number three, Tyrone Tucker was the person who actually killed Matthew Reed Bonnet, or Matthew Reed Bonnet was killed by a person other than Franklin Tyrone Tucker, but both Franklin Tyrone Tucker and the person who killed Matthew Reed Bonnet were principals in the commission of robbery. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of robbery, the state must prove the following four elements beyond a reasonable doubt. Number one, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number two, force, violence, assault, or putting in fear was used in the course of the taking. Number three, the property taken was of some value. And number four, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim, when it appears the person making the threat has the ability to carry out the threat and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist in any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that the knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. Counts 1 and 2 are linked in that the crime charged in count 2, robbery, is an essential element of the crime charged in count 1 of the indictment, first-degree felony murder. You should first consider the evidence applicable to count 2. If you find the crime in count 2 has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts 1 and 2. If, on the other hand, you find that the crime charged in count 2 has been proven beyond a reasonable doubt, you must then consider the evidence applicable to count 1. A guilty verdict on count 2 does not require a guilty verdict on count 1. You should find the defendant guilty on count 1 only if you find all the elements of that crime, including the essential elements contained in count 2, were proven beyond a reasonable doubt. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of first-degree felony murder is second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Matthew Reed Bonnet is dead. Number 2, the death was caused by the criminal act of Franklin Tyrone Tucker. Number 3, there was an unlawful killing of Matthew Reed Bonnet by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. And number 2 is done from ill will, hatred, spite, or an evil intent. And number 3 is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Excuse me. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number 2, force, violence, assault, or putting in fear was used in the course of the taking. Number 3, the property taken was of some value. And number 4, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear. An actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting it in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting it in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of the victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. If you find that Franklin Tyrone Tucker committed robbery, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried a knife, you should find him guilty of robbery with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Franklin Tyrone Tucker committed robbery, but you are not convinced beyond a reasonable doubt that he personally carried a weapon, then you should find him guilty only of robbery. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. Number 1, Franklin Tyrone Tucker intentionally and unlawfully threatened, either by word or act, to do violence to Roger Allen Roggett. At the time, Franklin Tyrone Tucker appeared to have the ability to carry out the threat. Number 3, the act of Franklin Tyrone Tucker created in the mind of Roger Allen Roggett a well-founded fear that violence was about to take place. And number 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Roger Allen Roggett may be found to have been in fear. An actual fear on the part of Roger Allen Roggett need not be shown. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Franklin Tyrone Tucker actually and intentionally touched or struck Roger Allen Roggett against his will. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. If you find that Franklin Tyrone Tucker committed crimes charged, you also find beyond a reasonable doubt that Franklin Tyrone Tucker was personally wearing a hood, mask, or other device that concealed his identity, you should find Franklin Tyrone Tucker guilty of crimes charged while wearing a device that concealed his identity. If you find that Franklin Tyrone Tucker committed the crimes charged, but you are not convinced beyond a reasonable doubt that he personally wore a hood, mask, or other device that concealed his identity, then you should find the defendant guilty only of the crimes charged. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment and information for each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged with committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to say and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his testimony, his or her testimony, deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It's entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of a witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. As I explained, the evidence goes back, the written instructions go back, and these verdict forms go back. And I'm going to go over them verbatim right now as part of my instructions. They're not complicated. You should find them quite self-explanatory, but again, to be thorough, I'm going to take a moment here to review them. There's 4 separate verdict forms appropriately labeled to correspond with each of the 4 counts. So I'm going to start with verdict count 1, and you can see in big bold letters, there it is, identified as verdict form for count 1. In the upper left corner is the date line. When the jury has reached its verdict, the foreperson should put today's date, that's when you reach your verdict, which is January 25th, 2024. Right below the date line is the jurisdictional statement in the Circuit Court of the 16th Judicial Circuit in and for Monroe County, Florida Criminal Division. You will remember way back to jury qualifications, and we talked about everybody being a resident of the 16th Circuit, because in order to be a juror, you got to reside in a jurisdiction wherein the crimes were allegedly occurred and where the trial is taking place. So this tells us what the jurisdiction is. And then right below the jurisdictional information on the left is this, what we call the style of the case. State of Florida plaintiff versus Franklin Tyrone Tucker defendant. Case number 2017 CF 841CK. You've heard me say that multiple times. That's the case style and the case number. And below that is the heading of the form, and then there's 3 choices here. If the jury's verdict is we, the jury, find the defendant guilty as charged in the indictment of the offense of first-degree felony murder, the foreperson puts a check mark in the line ahead of that verdict, and then you see down here in the lower right is an area that says, so say we all, a line, foreperson. That's where your foreperson signs and then dates the verdict form. If the jury's verdict as to count 1 is we, the jury, find the defendant guilty of a lesser included offense of second-degree murder, well, then the check mark goes on that line. And then once again, signed and dated by your foreperson. And as to count 1, if the jury's verdict is we, the jury, find the defendant not guilty, then the check mark goes on that line and once again signed and dated in the appropriate place. We've got a separate verdict form for count 2. This one's 2 pages. It's the same format, and I'm not, it's got the same information above the heading. And again, it's verdict count 2. So if as to count 2, the jury's verdict is we, the jury, find the defendant guilty as charged in information of the offense of robbery, then the line ahead of that verdict is checked. And then the jury considers the questions or interrogatories if it's guilty as to robbery. Obviously, if you don't find the defendant guilty of robbery, you don't go to these questions. But I'm going through the form in chronological order, not by any means suggesting what your decision will be, but only explaining it as it's presented here. So we see some instructions. If you find the defendant guilty of robbery, you must then answer the following questions. First question, in the course of committing the robbery, was Franklin Tyrone Tucker in possession of a deadly weapon? One of 2 answers, yes or no. Whatever the answer is, if you get to that part, that's where the check mark goes. Yes in front of yes, no in front of no. And you go on to the next question. In the course of committing the robbery, was Franklin Tyrone Tucker in possession of a weapon? If you get to this interrogatory, once again, yes or no, lines ahead of both choices. Whatever the decision is of the jury, that's where the check mark is placed. And then the final interrogatory on the second page, in the course of committing the robbery, was Franklin Tyrone Tucker wearing a mask? Same choices, yes or no, check mark in front of that answer that the jury unanimously finds to be proven beyond a reasonable doubt. So, if the jury's verdict was guilty and as to robbery, and you get through all those interrogatories, then the foreperson, again, this time it's on the second page, but it's again in the right-hand bottom part, signs and dates the verdict. Now, if the jury's verdict as to count 2 is we, the jury, find the defendant not guilty, so then there's where the check mark goes. You don't get those interrogatories, and you just have the foreperson sign and date the verdict. That's count 2. Count 3, separate verdict form, so labeled. Same format at the upper portion. Again, heading clearly says count 3. And then we look at the choices that the jury, the decisions available to the jury. If it is, as to count 3, we, the jury, find the defendant guilty as charged in the information of aggravated assault, the offense of aggravated assault, that's where the check mark goes. And then you look at the instructions immediately below that finding, and you're told if you find the defendant guilty of aggravated assault, you must then answer the following questions. It's actually only one question. In the course of committing the aggravated assault, was Franklin Tyrone Tucker wearing a mask? Once again, there's yes or no options, lines in front of each one. If you get to this interrogatory, you check which one of those 2 options the foreperson does. The jury so finds, signs, dates the verdict form by the foreperson. As to count 3, if the jury verdict is we, the jury, find the defendant not guilty, then the check mark goes in front of that verdict and signed and dated by the foreperson. Separate verdict form for count 4, same heading, label, count 4. If as to count 4, the jury's verdict is we, the jury, find the defendant guilty as charged in the information of the offense of battery, that's where the check mark goes, ahead of that verdict. And then following the instructions, if you find the defendant guilty of battery, you must then answer the following question. In the course of committing the battery, was Franklin Tyrone Tucker wearing a mask? Yes or no? Check the line in front of the answer that you find if you get to this interrogatory. As to count 4, if the jury's verdict is we, the jury, find the defendant not guilty, there's the line ahead of that verdict that's checked. And once again, when you complete the verdict decisions as to count 4, so say we all, signed by the foreperson, dated on the date. A separate crime is charged in each count of the indictment and information, and although they may have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged, except as explained in the instruction for legally interlocking counts. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. And I'm going to explain a little bit more about how we handle that provision here in the 16th Circuit in just a moment. If you need to communicate with me, send a note for the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. And that includes this unit here. That's going to go back. Its operation is fairly straightforward. So if you care to view any of the video evidence, you'll be able to do so. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So I'm going to ask attorneys to approach the bench. Can I see this a second, please? Remember back in jury selection when we talked about alternate jurors? And we heard from a couple of folks who served in alternate jurors, and I explained, I believe at that time, the importance of alternates and how I didn't relish by any means excusing alternate jurors because, as has been the case in this particular case, our alternates have been here throughout, just as attentive and patient and involved as the first 12. And now I have to excuse you because the first 12 jurors have been here throughout and are now ready to deliberate, and the law doesn't allow any more than 12. So one might ask, well, why were we here, Judge? I mean, goodness gracious, we've listened all this time. We'd like to share our thoughts now that we've spent all this time here. We'd like to hear what the others think, and you're denying me the opportunity. I understand that feeling entirely. All I can tell you is that more often than not, in trials, especially one of this duration with this number of jurors, things happen where one or more of the first 12 are unable to complete the case. If we don't have an alternate, to sit in that very seat that's been vacated, we have a mistrial. And you already heard instructions about how a mistrial is a, waste of time and inconvenience on a cost and all the above. So we try to avoid that by having alternates. In this case, we haven't needed them. So with my sincere thanks, I'm going to excuse Ms. Van Stryke and Mr. Amsterdam. But thank you very much. I certainly appreciate your service and your involvement. So just a couple other things. I'm going to give those folks a moment to clear the jury room. Just give a few further explanations about some of those instructions.
So I think what I'll do is I'm going to go back to the doulos case. You guys are saying that it's picking up a little bit, so let's do that. There is a bunch watching and streaming the Crumbly case. So I might do that off and on, but let's go back to the doulos case. We'll check it out, see what work we can learn, and I'll keep an eye on the courthouse here and get that out as soon as I can find something. Let's hope that they do this faster than not.
It's called a lockbox in the jury room. So you bring them in there.
So yeah, back to Saul. Oh my God.
Right before your very eyes, they're placed in the lockbox. It's secured. There it sits. So I think that
drives me crazy.
A little bit more security and assurance that their devices aren't going to be compromised. Not that they would be, but just in terms of state of mind, they're right there. And when you're finished, they're there for you to repossess.
Much appreciated, friend. I like to get everybody's input. You guys are awesome.
Notepads.
Good to see you, P9. They're just getting ready to deliberate. So we're going to wrap up this stream in a minute or two and then head over to the doulos case again with Michelle Troconis.
Nothing with any kind of marks on it, but a clean page and in legible, complete.
They just read the jury instructions, so not so much.
Whatever it is you want to ask me or tell me, Judge Jones. Then, when it's complete, the foreperson should put his or her name, fold it in half, knock on the door, give it to the bailiff. The bailiff will alert me, give it to me. I'll look at it. I'll share it with everyone, the lawyers.
Okay, guys, so I'm going to wrap this one up and jump on to the other stream. So if I get any kind of signal that there's a verdict, we will be on it. So guys, thanks for being here with me. I'll see you on the other stream. Bye. Hey guys, welcome to the think tank. So we are just getting set up here for the Michelle Troconis trial. Let me see here. Let's get this popping. Come on, come on. So yeah, we're going to wait on a verdict for Tyrone Tucker. There we are. Let's do this and this. We're going to do that, and we will do that. So here we are. Put on some volume.
Judge, good morning. Are those for today anyway, or was that for, that's all in the second, I think. Yeah.
What are we doing here?